Welcome to Gough Square Live. In this edition, Robin and I will discuss the two main statutory routes of appeal following the service of an enforcement notice: the Magistrates Court sitting in its civil jurisdiction and the First-tier Tribunal. Our main examples come from food law, but many of the principles apply equally in other regulatory areas. We say statutory routes because we will not be considering judicial review as a route of challenge. In many cases, judicial review is unlikely to be a viable option where the recipient of a notice has an alternative route to challenge an enforcement decision.
The decision to challenge a notice is an important one and should be made after careful consideration of all available options. It's essential that the business notifies their advisors as soon as possible after receipt of a notice so that all necessary investigations can be made. There may be a reluctance to do so due to cost implications, but an initial discussion shouldn't cost much. Ian was recently involved in a case where the officials required the destruction of a significant quantity of foodstuffs which were alleged to have breached safety and hygiene regulations. And further down the line, during the criminal investigation, there was a good argument to say that there had been no breach of the relevant legislation due to the officers making a factual mistake and not applying the law correctly, and that the food was in fact safe. The cost to the business occasioned by the destruction was substantial, and this might have been avoided. So the key takeaway for a business is to take prompt action following receipt of an enforcement notice and consult advisors at the earliest opportunity. Of course, there may not be a statutory power of appeal, or the notice shouldn't be appealed, but early consideration prevents rushed last-minute decision-making. Sometimes this is inevitable, and both Ian and I have received last-minute instructions to advise and draft the applicable paperwork. But after the appeal process has been commenced, it may be that on mature reflection, the most appropriate course of action would have been to comply with the notice or to find an alternative way forward short of a formal appeal. That being said, an appeal may be the correct approach, and if so, what are the key things to be aware of when considering an appeal?
So, is the decision or notice susceptible to a statutory appeal? Not all enforcement action gives rise to a right of appeal under the relevant statutory provisions. So an authorised officer may serve a hygiene emergency prohibition notice where they are satisfied that the health risk condition is fulfilled with respect to any food business. And that's Regulation 8 of the Food Safety and Hygiene England Regulations 2013. However, there is no statutory appeal against this notice, and the only challenge is really to resist an application for a hygiene emergency prohibition order in the Magistrates Court. A hygiene emergency prohibition notice or a hygiene emergency prohibition order ceases to have effect on the issue by the enforcement authority of a certificate to the effect that they are satisfied that the food business operator has taken sufficient measures to secure that the health risk condition is no longer fulfilled with respect to that business. And that's Regulation 8.8 of the 2013 regulations. However, if the authority then refuses to issue a certificate, that refusal may be appealed to the Magistrates Court under Regulation 22. It is also important to be clear what the officer or authority has done and what the legal effect of that decision is. For example, in an importation case, the authority might indicate that the rules have been broken and they threaten to take action under a particular statutory provision. But in the absence of a formal decision complying with the legal requirements, that mere threat is unlikely to engage the provisions of the regulations and hence is not subject to a statutory appeal. I was involved in a case where this issue arose, and by seeking early legal advice, the client was able to focus their efforts on an alternative way forward. If there is no statutory power to appeal, a judicial review might be possible, but this can be costly and requires very careful consideration.
Moving on then to the competent authority. In many cases, this isn't a live issue, but nevertheless, it's important to check the legislation to ensure that the enforcement notice has been served by the correct competent authority, which we'll discuss later in the related issue of the officer being properly authorised. An example of this is in practice something that can be seen in the welfare of animals at the time of killing England Regulations 2015, known as WATOC. Regulation 4 states that there are two competent authorities, the Food Standards Agency and the Secretary of State, or DEFRA. The FSA is stated to be the competent authority for purposes specified in that regulation, and otherwise, the Secretary of State is the competent authority for the purposes of the EU regulation and these specific regulations. Regulation 4 of the Food Safety and Hygiene England Regulations 2013 defines the competent authority as either the Food Standards Agency or a food authority, which is usually a local authority. So, if the notice was served by the wrong competent authority, this might be the end of the matter, unless, of course, the correct competent authority intervenes and serves a fresh notice.
So then what about the potential for an informal challenge? So businesses will often seek to avoid formal enforcement notices being served at the time of the officer's inspection. The business might voluntarily offer to take action that might otherwise be required by a notice. For example, they might say, we'll close the restaurant, we'll do a deep clean, or we'll stop doing something and invite the officer to return in 24 or 48 hours. Unfortunately, this does not often work as the officer is overstretched and often has enough on their plate, and trying to get them to find time to add a return visit in a day or two to see if the action has been taken is not always easy. In fact, I was in a case where the officer said as much near the end of a day whilst inspecting a restaurant. This does serve a reminder that decisions regarding the service of enforcement notices can often depend on the individual officer, although all officers will quite rightly demand full legal compliance by the most appropriate means. Even where a notice has been served, it may be possible to take action and then ask the officer to withdraw the notice. But of course see the power of appeal if they don't withdraw or they don't make an equivalent decision.
So, do you launch a statutory appeal or not? Of course, every case is different and every business is different, and that's why early warning that an enforcement notice has been served is crucial. But pursuing a statutory appeal requires careful consideration, and several factors need to be considered. For example, time, the cost, the factual merits, legal complexity or legal simplicity, chances of a successful outcome, and what it really means for the business. Some businesses are quite risk averse and may not want to appeal for fear of upsetting the officer or the competent authority. In other cases, the enforcement notice might require the business to spend a significant amount of money and in fact redesign their procedures and their premises. In this case, the balance is likely to be in favour of pursuing an appeal. Even if the appeal isn't wholly successful and that the notice isn't cancelled, it might be possible to negotiate an outcome that isn't as harsh as it would otherwise have been.
So what are the possible avenues of appeal? As already mentioned, each case is different, but the following might fall to be considered when deciding how to formulate an appeal. On their own, some may not be sufficient to provide reasonable grounds for a successful appeal, but in combination they may allow a good case to be formulated and developed. In an appropriate case, the number of potential deficiencies might result in the appeal being allowed without a hearing, and the notice may then be withdrawn. So legal and procedural points might include questions around, well, was the officer properly authorised to take the action they took or purported to take? Has the officer followed the applicable statutory provisions? Does the notice itself comply with the statutory provisions? These provisions might require the notice to include matters such as the officer's grounds for believing there's been a breach of the relevant regulation. In what way is the officer saying the business is not complying? And what must the business do to become compliant? There must also be a time frame within which the business must take action. So has the correct person been identified? Has the correct duty holder been identified? And if applicable, has the notice been served in accordance with the appropriate statutory provisions for service? So factual challenges might include, well, the conditions in the premises or the factual basis for intervening is not sufficient to use the enforcement notice procedure. So has the business gathered its own evidence at the time of the inspection that will be sufficient to contradict the photographs and the oral evidence the officer will present to the court? It may be possible to engage an expert to comment on the officer's evidence, to suggest, for example, why the statutory criteria are not made out. But from a business perspective, this may not be sufficient to show that the requisite criteria are not made out. Although not perhaps an appeal point, a business faced with an application by the officer for a hygiene emergency prohibition order may be able to deploy expert evidence on the question of whether there was an imminent risk, the statutory criteria. However, where food safety and hygiene are in issue, the court often prefers to take decisions based on consumer protection and often side with the officer's evidence. Can you challenge what I might call the mental state that is required to serve an improvement notice or an enforcement notice? So the grounds for serving the notice will require the officer to have formed a view, using a neutral word, about the conditions or the activity observed and whether in fact they amount to a contravention of the relevant legislation. How that view is described differs. You might have reasonable grounds for believing, for example in Section 10 of the Food Safety Act 1990 in terms of improvement notice, and who is of the opinion that the relevant regulations have been breached under WATOC, as Robin mentioned earlier. Having regard to the purpose of the legislation, which is consumer protection and animal safety in that case, these words create a relatively low threshold compared with the beyond reasonable doubt test for proving a criminal offence based on the same set of facts and circumstances.
So, let's say after all that you've decided to appeal. What factors are now in play? Well, first you might think about which court. If you're in the Magistrates Court, where are you going to issue proceedings? Second, what's the time limit? In many cases, there will be a statutory time limit, and it's very difficult to defeat that if you get it wrong. Third, you might think about, well, who can appeal? Who is the legal person who will be appealing? Fourth, what are the procedural requirements? Which documents do you need to have in? Fifth, how long before the appeal is it going to be listed? All of these things are things you're going to need to be thinking about.
So then I'll turn to deal with the Magistrates Court. The legislation must be carefully reviewed to ensure that provisions are complied with, but the following principles are often applicable. Many statutory provisions provide that a person may appeal if they are, quote, aggrieved by the decision to serve the notice, for example, an improvement notice, which is applied in several statutory instruments. Section 37 of the Food Safety Act 1990 provides that such a person may appeal to the Magistrates Court, and the procedure on appeal is set out in Part 2 of the Magistrates Court Act 1980 and the Magistrates Court's Rules 1981. This is the Magistrates Court's civil jurisdiction. The appeal must be commenced within 1 month and is commenced by way of a complaint for an order. Depending on the issues, the case is likely to be listed for an initial hearing at which the court may issue directions for example, the provision of evidence, bundles, skeleton arguments, and may set a timetable for the final hearing. I was involved in a case which was urgent, and the enforcement notice itself said that in the case of an urgent matter, the appeal should be brought before a particular court. With all the pressures on the court service and the difficulty in communicating with the court, it was actually impossible to obtain an urgent listing at that court. The client then gave some thought to pursuing judicial review proceedings to defend the business's interests and to force a court to hear the appeal. Luckily, this proved to be unnecessary, but it serves as a reminder of the frustrations that are sometimes felt in getting access to the court system. On hearing the appeal, the Magistrates Court may cancel the notice or affirm the notice, including by way of modification. Costs are subject to the provisions of Section 64 of the 1980 Act, which gives the court a broad discretion as to liability for costs and for quantum. In brief, costs do not necessarily follow the event. The loser does not always pay the winner, particularly if the regulatory authority acted honestly, reasonably, properly, and on grounds that reasonably appeared to be sound in the exercise of its public duty. This is an important factor for the business to consider when deciding whether to appeal, because even if it is successful, it may not recover its costs. And there are some standard cases on this, the Bradford and Booth case of 2000, and more recent case involving the Competition and Markets Authority and Flynn Farmer, and the Commission of the Police of the Metropolis and Malik and Ealing Magistrates Court, a 2023 decision. An aggrieved unsuccessful business may appeal further to the Crown Court or to the High Court by way of case stated.
So that's the Magistrates Court. Let's talk now about the First-tier Tribunal. Several statutory instruments apply Section 10 of the Food Safety Act and permit the service of an improvement notice. But rather than providing for an appeal to the Magistrates Court, the appeal lies to the First-tier Tribunal, for example, the Honey Regulations 2015. The First-tier Tribunal is governed by the Tribunals, Courts and Enforcement Act 2007 and the Tribunal Procedure First-tier Tribunal General Regulatory Chamber Rules 2009, and it's procedurally more structured than the Magistrates Court. It's worth pausing briefly to explain why. The tribunal system was designed to provide a more specialist and more flexible forum for regulatory disputes. Unlike the Magistrates Court, which is primarily a criminal court exercising a civil jurisdiction for these appeals, the tribunal is purpose-built for administrative and regulatory decision-making. What that means in practice is that the tribunal tends to be more proactive in managing cases, more structured in its approach to evidence, and perhaps sometimes more comfortable dealing with technical, regulatory, or legal issues. The appeal must usually be commenced within 28 days of the decision being appealed, so the time limit is again important. The procedure is front-loaded. The appellant serves the notice of appeal, the authority files a response, and the appellant may file a reply. From an early stage, the tribunal will often issue directions setting out what evidence is required, how it should be presented, and what the real issues in dispute actually are. And in our experience, this is one of the biggest differences from the Magistrates Court. You tend to get more active case management from the tribunal, identifying the agreed facts, narrowing the legal issues, limiting the scope of the evidence, and setting the parameters of expert evidence. For both prosecution and defence practitioners, this can be very helpful, but it can also be uncomfortable if a party hasn't properly thought through its case at an early stage. Another major difference is that the tribunal process is often more document-driven than the Magistrates Courts. Tribunal appeals are often decided on written witness statements, documentary evidence, expert reports, and written submissions. Oral evidence is still important, of course, particularly where credibility is an issue, but in our experience, the tribunal tends to expect the parties to present a clear written case. So poorly organised bundles, unclear chronologies, or unfocused evidence tend to be exposed very quickly. When it comes to technical scientific expert evidence, the First-tier Tribunal also seems to be more comfortable than at least some magistrates' courts. One example from my own practice, which really illustrates how the First-tier Tribunal can handle technical evidence effectively, is the case of Odysseia Limited and London Borough of Waltham Forest. This was a food labelling case concerning raw honey. Odysseia sold honey which it described as raw honey. The local authority took issue with that on the basis that it was a misleading food description. And the reasoning essentially went that you don't cook honey, so all honey is raw, and it's misleading to suggest that there's something special about your honey, when in fact all honey is raw. And in doing so, the local authority relied heavily on national guidance from the ACTSO when adopting that reasoning. But when the matter came before the tribunal, the focus shifted away from simply applying guidance and more towards analysing the underlying scientific evidence. What was particularly striking was that the tribunal was prepared to engage directly with the laboratory evidence, the methods used in manufacturing different types of honey, the assumptions which have been built into the ACTSO guidance, and the actual scientific basis for the enforcement position. The case was largely dealt with on the documents. There was live evidence, but the case really came down to the science, statutory interpretation, and whether the ACTSO guidance was correct. Importantly, the tribunal didn't treat that national guidance as determinative. Instead, it made clear that the guidance was exactly that. It was guidance, and that where the scientific evidence didn't support the regulatory conclusion being advanced, the tribunal was willing to depart from it. And so the First-tier Tribunal concluded that scientifically there really was something special about Odyssea's honey that differentiated it from other honeys on the market, and the tribunal had no qualms in expressly disapproving the ACTSO guidance. I do wonder whether that case might have been handled quite differently in a magistrates court. Moving on then briefly to costs, the tribunal's powers to award costs are limited. In general, costs will only be awarded where a party has acted unreasonably in bringing, defending, or conducting the proceedings, or where there's been unreasonable, improper, or negligent conduct by legal representatives. That's a very high bar. For businesses, it's important to understand that even a successful appeal will not usually result in the recovery of legal or expert costs, and that needs to be factored into the commercial decision about whether to appeal. As for appeals onwards, an appeal from a decision of the First-tier Tribunal lies to the upper tribunal on a point of law only, and permission to appeal is required. This underlines the importance of getting the case right at the first stage, both factually and legally.
So perhaps to wrap up now, receiving an enforcement notice can be a very worrying time for the business, and knowing quite how to respond can be daunting. However, with careful thought and a full assessment of the legal, practical, procedural and commercial issues, the business and its advisors can find a route to address the issue, perhaps by way of compliance, negotiation or legal proceedings. A successful appeal to the Magistrates Court or to the Tribunal may result in the enforcement notice being cancelled, which could avoid the expense and disruption of having to comply with the notice in the first place. However, getting to that decision may be costly, and those costs may not be recovered by the successful business. Well, that's all for today. Thank you very much for joining us, and we hope you will join the next Gough Square Live broadcast.
Goodbye.
Goodbye.